Cross-border M&A can offer tremendous opportunities, but also significant legal risks. Different legal systems, languages, regulatory expectations, and cultural norms all increase the complexity of international transactions. In Vietnam, these risks are amplified by evolving laws, limited transparency, and sector-specific restrictions. In this video, we share the key legal strategies that foreign investors should use to mitigate legal risk when acquiring or merging with Vietnamese businesses. Legal due diligence is your primary defense against hidden liabilities and compliance issues. The earlier you start, the better. A thorough legal review uncovers problems with licensing, ownership, corporate structure, litigation, tax exposure, labor compliance, and more. Starting due diligence after commercial terms are finalized limits your ability to restructure the deal based on risks found. Legal due diligence should begin as soon as the target is identified and should be scoped appropriately to match the transaction type and industry. Vietnam has general laws governing M&A, but many sectors have their own specific restrictions and licensing requirements. Foreign ownership may be capped in logistics, advertising, education, real estate, and other sectors. Some industries require advance approvals, special licenses, or post-deal filings. Understanding how general laws intersect with sector-specific regulations is essential to avoid regulatory blocks or post-closing enforcement. Legal counsel should conduct a regulatory mapping early to anticipate these requirements. Term sheets are not just business documents, they can be legal risk management tools. Include essential legal clauses such as confidentiality, exclusivity, governing law, dispute resolution, and liability limitations in your term sheet. Doing this helps prevent misunderstandings, protects sensitive information, and provides a legal foundation for negotiating definitive agreements. Avoid generic templates. Use transaction-specific term sheets drafted with legal oversight. The SPA or investment agreement should contain clear and comprehensive representations and warranties from the seller. These include statements on ownership, compliance, taxes, labor, environment, contracts, and financials. If any of these are inaccurate, you must have the legal right to seek compensation. Representations and warranties allocate legal risk by ensuring the seller is accountable for the true condition of the business. When legal due diligence identifies specific risks, such as pending lawsuits, unregistered IP, or tax liabilities, these should be covered by tailored indemnity clauses in the contract. An indemnity requires the seller to compensate the buyer directly for specified losses. This allows you to proceed with the transaction while isolating exposure. Indemnities should include clear time limits, liability caps, claim procedures, and escrow arrangements to be enforceable and effective. If your transaction meets certain thresholds under Vietnam's competition law, merger filing is required. If you acquire 50% or more of a company in a conditional sector, M&A approval may also be needed from the Department of Finance. Skipping these approvals can result in administrative penalties or the transaction being declared void. Legal advisors should assess whether these filings are required and prepare dossiers in advance to avoid last-minute delays. Ownership of real estate, equipment, intellectual property, and core assets must be legally verified. Many companies operate with expired or incomplete licenses, lease land from third parties without legal registration, or use trademarks registered under individual names. Relying solely on verbal confirmation or internal records is risky. Legal teams must review title documents, licenses, contracts, and registrations to confirm what is being acquired and whether it can be legally transferred. To manage payment risk, buyers should negotiate an escrow arrangement or holdback provision. These mechanisms withhold part of the purchase price until certain conditions are met or risk periods have passed. If a problem arises post-closing, funds are available to cover losses. This reduces the chance of having to chase the seller for payment and strengthens the buyer's leverage in post-closing claims. Disputes may arise even with the best planning. The SPA should include a well-drafted dispute resolution clause. Options include Vietnamese courts, foreign courts, or international arbitration. Many foreign investors prefer arbitration due to confidentiality and enforceability. The choice of governing law and forum has major implications for legal costs, time, and outcomes. Risk management does not stop at signing. After the deal closes, buyers must ensure that all post-merger filings, license updates, employee transitions, and tax registrations are completed. Delays or errors in post-closing compliance can result in penalties or disruption of operations. A post-closing checklist should be assigned to the legal team or advisors to track and monitor required actions through completion. At LTS Law, we specialize in helping foreign investors reduce legal risk in cross-border M&A deals. From legal due diligence and contract drafting to regulatory compliance and dispute resolution, we act as your strategic legal partner. We do not just identify risks, we help you manage and control them from the start to long after the deal is closed. If you are planning a cross-border M&A transaction in Vietnam, do not leave risk to chance. Let LTS Law help you mitigate legal exposure and protect your investment. Visit lts.com.vn to request a consultation. In a deal environment full of uncertainty, legal strategy is your greatest advantage.